All right, if you're in the home healthcare business in India, listen up. There's a brand new law that you absolutely need to have on your radar, like right now. So let's get into it. We're going to break down India's new Digital Personal Data Protection Act and figure out what it actually means for how you run your business every single day.
So let's just jump right to the number that's making everyone sit up and pay attention. 250 crores. Yeah, that's 2.5 billion rupees. And this isn't some theoretical number, it's the absolute maximum penalty you could face under this new law.
And that number, well, it leads to a pretty direct, maybe even a little scary question. It's a massive figure, enough to completely derail pretty much any business. So you have to ask yourself honestly, is your organization ready for this?
Okay, to really get a handle on this, you've got to understand that we're not just talking about another piece of red tape or a new regulation. No, this is a complete, fundamental shift in how we have to think about and handle patient information.
This law didn't just pop up out of nowhere. It's been over a decade in the making. The whole conversation really got started back in 2014 with the Aadhaar Act. Then, the real turning point was 2017, when the Supreme Court actually declared data privacy a fundamental right. So after all that, the act was finally passed in 2023, and we're expecting the final rules to roll out in 2025. The key thing to remember? This has serious momentum, and it is here to stay.
And let's be crystal clear about something. The DPDP Act, it's not a suggestion box. It's not a list of best practices. It's a law, and it's tied directly to the Constitution under Article 21. That means it is absolutely mandatory for every single organization, big, small, you name it, that handles personal digital data.
All right, so if you're going to play the game, you've got to know the rules, right? And this law comes with its own vocabulary. There are some new terms you really need to get familiar with because they define everyone's roles and responsibilities in this new world.
First up is this term, data fiduciary. And just so we're clear, if you run a home healthcare agency, that's you. Yep, you're the one deciding why you're collecting patient data and how you're going to do it. And that means the primary responsibility and all the liability sits right on your shoulders.
Then on the other side of the coin, you've got the data principle, and that's your patient. This whole law is really built to empower them. It gives them a whole new set of rights over their own personal information, how it's used, who it's shared with, and how it's stored.
Now, you might be thinking, hey, isn't this basically just India's version of Europe's GDPR? And, well, kinda, but not really. The spirit is similar, but the details are very different. For instance, the DPDP Act only covers digital data, while GDPR covers physical paper records too. The penalties are a fixed absolute number, not a percentage of your revenue. And for getting consent for a child's data, the age is anyone under 18. These details really matter for your operations.
All right, enough with the theory. Let's talk about what this actually looks like on the ground in your business day to day, because this is where we start to see some super common everyday practices that have suddenly become huge new risks.
I want you to just take a second and be honest with yourself. How many times a day does a caregiver send a quick patient update, maybe a photo of a rash or a question about medication to a supervisor over WhatsApp? It happens all the time, doesn't it? Well, under the new law, that's a massive problem. The Act is incredibly clear on this. Using informal, unsecure platforms like WhatsApp to share sensitive patient data is strictly 100% not allowed. Period. End of story.
And that's really just the tip of the iceberg. Think about it. Caregivers jotting down notes on their personal phones, relying on a quick, verbal, yeah, that's okay from a family member for consent, keeping patient logs in a simple Excel file or a Google Sheet. All of these things, which probably feel totally normal, are now major compliance risks.
And here is maybe the most important thing you need to understand. If one of your caregivers makes a mistake and shares data when they shouldn't have, the penalty doesn't fall on them, it falls on you. The liability is always on the organization. The buck stops with you.
Okay, I know. Hearing all this, it can feel a little doom and gloom, right? It's all about penalties and risks. But what if we flipped the script? What if we looked at this whole thing as a massive opportunity to build something invaluable? Trust.
This quote right here really gets to the heart of it. Protecting your patient's data isn't some separate IT problem. It's a core part of protecting their health. It's all part of the exact same circle of professional, compassionate care.
So I want you to try and stop thinking of this as just another cost on your spreadsheet. Instead, start seeing it as your new secret weapon. In a market that can be really fragmented and sometimes informal, being the one provider that takes data privacy seriously, that makes you stand out.
And we're talking about real, tangible benefits here.
You'll build way deeper trust with patients and their families. You suddenly become a much more attractive partner for big hospitals and labs because they have to worry about this stuff too. You protect your business from a devastating data breach, and you actually empower your employees by giving them clear, safe rules to follow.
Okay, so the big question is, where on earth do you even start? I know it can feel like you have to climb a mountain, but you don't. We can break this down into a simple, actionable plan. Let's look at the first 3 steps you can start working on today.
See, it really just boils down to these 3 things. Map your data, fix your consent process, and train your team. That's it. Let's just quickly touch on what each one means.
First, you have to become a data detective. You need to map out the entire journey your patient data takes. Where does it come from? Where do you store it? Who do you share it with, and why? You have to be able to identify every single piece of personal information.
Step 2 is all about consent. Gone are the days of that vague, one-line, I agree to everything checkbox. It's not good enough anymore. Your consent process has to be super clear, specific about what you're using the data for, and totally unambiguous. And yep, that means you have to go back and get fresh, proper consent for all the existing patient data you hold.
And finally, step 3 is about your people. Because you can have the best technology in the world, but it won't matter if your team isn't trained. This means getting them off insecure tools like WhatsApp, for sure, but it also means teaching every single employee why this is so important and what their personal responsibility is in protecting your patients.
So, we'll just leave you with this one final thought to chew on. As a home healthcare provider, your entire mission is to keep your patients healthy and safe. The question this new law is forcing all of us to answer is, are we putting that same exact level of care and dedication into keeping their data safe too?